All right, morning, folks. And who do we have as defense counsel today?
Yes.
Good work. Is our Zachary from the public defender's office, Your Honor?
Can you repeat your name? I'm sorry, it cut out.
Sorry, Jeremy Zarzicki.
Zarzicki?
Yep.
Okay, thank you, sir. And do we have Mr. Terrace today for the state?
Yes, Your Honor. Good morning. Just until Mr. Poston's back from court.
Okay, thanks. And then with the jail, do we have any updates on folks who are not wanting to appear today?
The only update, Your Honor, is Mr. Ucopicio.
Okay. All right, we'll order continuing him. If message can get to him though, that because I think we have someone in the gallery who's been coming to court wanting to get resolution on the case. Eventually, at some point, and no later than tomorrow morning, he's going to be forced to come to court if he doesn't appear. So unless he's hot. Oh, okay. So there's an extenuating. So I'm being told there's an extenuating circumstance why he can't appear. Is that correct?
There is, Your Honor.
Okay, I'm not entirely clear as to what that is, but I'll hold off for now. So we'll continue his matter. Sir, in the back of the gallery, I'm not exactly clear why I can't disclose or indicate we are live streaming right now. So there may be a personal or private medical reason, for example, he can't appear. That's as much information as I can provide right now. So if you have any way of contacting him while he's incarcerated, if you don't, but otherwise, I just can't give you any additional information. I know you've been showing up. I appreciate you trying to be supportive. So that's about as all, but we're not going to proceed with his hearing today. Yeah, I would say do that. And this is also live streamed as well on YouTube. If you just want to observe what's happening, you don't want to have any direct input. Are you a stated victim in the matter? So you could always watch on YouTube. If you go to the Justice Court website, there's a link that you can find to watch on YouTube instead. So you don't actually have to come into court to do it, if that helps. Okay, thank you, sir. You're welcome. Otherwise, I think we've got everybody. If the jail's ready, we could start taking folks. To clarify for the, if we have an interpreter present, I don't see any Spanish speakers, so you are free to go at this time. Thank you.
Mr. Ray will be first, Your Honor.
Thank you. And I'm showing a DOC hold on Mr. Ray, is that correct?
Brown chair.
Okay, good morning, sir. We're here today for an initial appearance. Can you identify yourself first and last name?
Andrea?
Mr. Ray, you're here today. Looks like a warrant was issued back in February 2025 for a prior offense of disorderly conduct. This is a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. To the jail, let me just confirm, do we have a DOC hold on Mr. Ray?
Correct, Your Honor.
Okay, so Mr. Ray, what that means is that the Department of Corrections has placed a hold on your case such that even if the court was inclined to release you on today's date, I can't do that at this time, or even if I did, you'd still be held. So what the court is doing in this case is setting a nominal bond of $250 cash or secured. But again, even if you post that bond, you will not be able to be released until the DOC hold is lifted. The court is going to affirm prior release conditions as to the disorderly conduct charged. And you are being appointed counsel because you're going to remain incarcerated. That's going to be John Illis, and he'll be able to get in contact with you. You have a hearing set this afternoon at 1:00 p.m. for a case management conference. So ideally, Mr. Illis will get in contact with you as soon as possible, speak with you about your case management conference. This hearing is set in order to resolve the disorderly conduct charge that arose from several years ago. A lot of information, sir. Do you have any questions at this time?
No.
Okay, you're excused. Thank you very much.
Thank you.
Okay, good morning, sir. Can you state your first and last name?
Good morning, Hector Rios.
Mr. Rios, we have you here today on, looks like there were some prior proceedings. There was a petition for a criminal restitution order that was filed and granted back in October of 2023. So my understanding is that you've been picked up for failure to appear as to revocation of probation. And the underlying offenses that we're discussing are misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. The assigned judge in this matter has requested that bond be set in this matter in order to assure your appearance on the information available to the court. The court approves that request. The court is setting bond in this matter at the requested amount of $2,499 cash bond. And the court will further affirm prior release conditions. You have your next court date to resolve this whole matter is on March 26, 2025, 1:30 p.m. at the Tucson City Court, and that's with Judge Million. And once you appear at that hearing, you should hopefully be able to resolve the pending matters before the court. Do you have any questions at this time?
Okay, no questions.
Okay, you're excused. Thank you, sir.
So, I have to pay what?
Or two. 250 with the lab.
$250
With
How do I get a hold of my people to do that?
Sorry, what was that?
Where do I go talk to the jail? Who do I talk to?
Talk to him this
Right now? How much do I have to pay?
You gotta, it's, the bond is 24.99.
Okay. $24.99?
Yeah.
How much would I have to give though?
If you go through a bail bond, it's 250 plus collateral.
250?
Plus collateral.
What's collateral?
Like a card.
Okay. All right, thank you.
Specialist. Yeah, give me a second. Give me a second. All right, folks, everything on the side. Do the middle, all around the person. Check. First.
Okay. Sounds good. Thanks. Okay, good morning, ma'am. Can you state your name, please?
Good morning, Guadalupe Dicochea.
Ms. Ducochea, we have you here today on a few misdemeanor charges for assault, disorderly conduct, and criminal damage. You do have a right to remain silent. Anything you say can and will be used against you. In review of the information before the court, at this time, the court is going to order that you be released on your promise to appear at future proceedings, but there are going to be several conditions of release. No drugs or alcohol, no acts of domestic violence, no firearms or weapons to be possessed by you. No contact with the victim, Mr. Is it Niemer? Arthur Niemer. You're not to go to his residence or workplace. The court is going to set your next hearing as an arraignment on these charges at the Sahuarita Municipal Court, April 1st, 2025, 8:30 a.m. That's April 1st at 8:30 at the Municipal Court, Sahuarita. If you do not appear, a warrant could be issued for your arrest, so do make sure that you appear. Any questions at this time before you're released?
No,
Okay, then you're excused. Thank you, ma'am.
thank you.
Mr. Wood?
Good morning, sir. Can you state your name, please?
Good morning, Key John Woods.
Thank you, Mr. Woods. We've got a couple of matters for you today, so we'll take them one at a time. Just give me one moment to get your files up. Yeah, let me just double check. Do we have, it looks like we may have a Superior Court hold on Mr. Woods. Is that correct, Jail?
Correct, Your Honor.
Okay. So in general, Mr. Woods, you're here today on a couple of failures to appear. There was a minor possession of alcohol charge. In addition, there was a charge for, get the other one up, criminal damage. In general, you do have a right to remain silent as to these pending matters. Anything you say can and will be used against you. The Superior Court has placed a hold prohibiting you from being released at this time. So even if the court was inclined to release you on today's day, I wouldn't necessarily be able to do it. What the court is going to go ahead and do is set nominal bond in this matter in the $100 in the amount of $100 cash is secured. That'll be consecutive in each matter. So total bond of $200 required. Until that hold is posted or is resolved with the Superior Court, the court's unable to release you at this time, and so the court is going to appoint counsel for you since you don't have, since you are being held at this time. Let me just, it's going to be Gary Brinkowicz is going to be appointed to represent you on today's date. Court's going to go ahead and affirm prior release conditions, and so your next court dates in this matter for these failures to appear, that's going to be on March 13, 2025, 1:00 p.m. So that'll be tomorrow, 1 o'clock, with Judge Ball at the Justice Court. So that'll be your first opportunity to get these charges resolved. But again, even if they're resolved and you're able to be released, there's still that hold that needs to get resolved. And I don't have a lot of information on that right now, so I can't really address that with you more fully. In any event, do you have any questions, sir, at this time?
No, I do not.
Okay, so then you are all, I believe you're all set. You can be excused. Thank you, sir. Okay, just one moment, ma'am. Almost ready to go. Okay, sorry about the delay, ma'am. Would you please state your first and last name?
Jacqueline Bell.
So we have you here today on looks like a failure to appear for a prior charge of theft. It looks like there was a warrant that was issued on or around August 7, 2024. Case has been open since approximately 2022. So you do have a right to remain silent. Anything you say can and will be used against you. In order to ensure your appearance at future proceedings, the court is going to set bond in the amount of $500 cash or secured, and any prior release conditions are affirmed. You do have your next court date in this matter, March 21st, 2025, 1:45 p.m. for video review with Judge Mayhew at the City Court. If you do post bond and you're released after posting bond, you still need to go to that video review hearing at the City Court, March 21st, 2025. Any questions at this time?
Yeah, I understand that the warrant was for $250. So would the bond be higher than the actual warrant?
Let me double check. I'm not sure if I have warrant information at this time. Oh, here we go, right here. Do I have to? I can set then date. Yeah.
That's written, is there an update there? Or is it the same?
Sorry, just one moment. We're just trying to figure out the setting that there is an update here. Yeah.
Yeah,
Okay, do you want me to indicate that as well?
yeah, just that if she's released, that she can come in on her.
Okay, so the court at request of the defendant, the court will reduce bond to be indicated. The court will set bond at $250 cash or security. And so there are a couple of dates that you have then under the circumstances, Ms. Spel. We have the video review if you're still incarcerated, March 21st, 2025, 1:45 p.m. However, if you do post bond and you're released before then, you can also, in the alternative, go to your April 16, 2025, 2:00 p.m. hearing. And that's also at the city court. So you have a couple of dates. If you do get released before the video review, you can go to the April 16, 2025, 2:00 p.m. date. The court will appoint the city public defender's office to represent you in this matter. Did you want me to restate anything or did you have any questions, ma'am?
No, I suppose I could talk to your staff here on how I could pay the $250 bond from inside here. So I don't have any further questions. Thank you, Your Honor.
Okay, thank you. Your excuse, ma'am.
Brian Guthrie.
Good morning, sir. Can you state your name, please?
Christopher Guthrie.
Is we show that there's a different name listed. Do you go by any other names?
No,
So what is your legal first name?
Ryan, Ryan.
Okay, that just want to make sure we've got the same individual. So Mr. Guthrie, then you are here today on account of disorderly conduct, a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. Does not appear that pretrial services was able to contact the alleged victim in this matter. Without that input, at this time, what the court's going to go ahead and do is as follows. The court is going to order that you be released on your promise to appear at future proceedings. However, the court is going to order that you not have any contact with the victim, Amanda Metz. You're not to go to her residence or workplace. If you do happen to share that residence with Ms. Metz, the court is going to order that you are permitted to return one time with law enforcement to retrieve your belongings. The court is going to set your next court date as April 8th, 2025, 1:30 p.m. at the city court, and that will be with Judge Millian to have your next hearing on these charges or this charge. Make sure that you go to your future court date. Failure to appear can result in a warrant being issued for your arrest. Did you have any questions, sir, at this time?
No, sir.
Okay, then you're excused. Thank you.
Silva, Dean.
Good morning, sir. Can you state your name, please?
Dean Silva.
Mr. Silva, we've got you here today on some failure to appear for some charges in 2024. Criminal trespass, drug paraphernalia, theft, and also another drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You have working transportation at this time?
Yes.
And so if the court set a court date for you to attend, are you able to appear at that court date?
Yes, sir.
And then, so if the court gave you an opportunity to do that in lieu of holding you, would you promise to appear at future proceedings?
Yes, sir.
All right, so the court at this time is going to order the defendant be released on his promise to appear at future dates. The court is going to order that there not be any possession or use of alcoholic beverages or illegal drugs as a condition of release. And any prior release conditions are also affirmed. Next court date in this matter will be a pretrial hearing that's set April 14, 2025, April 14, 2025, 2:30 p.m. And that'll be with Judge Cranshaw at City Court. Judge Cranshaw already issued a warrant for failure to appear, so I don't think that he'll hesitate to do it again, Mr. Silva. Do make sure that you appear April 14, 2025 at that hearing. Okay, sir?
Yes, sir.
All right, you're excused.
Valenzuela Rodriguez.
Okay, good morning, ma'am. Can you state your name, please?
Joanna Valenzuela.
Okay, do you go by Joanna Valenzuela Rodriguez?
Yeah.
Yes.
So, ma'am, you're here today on a few misdemeanor charges for endangerment, assault, and disorderly conduct. You do have a right to remain silent. Anything you say can and will be used against you. In review of the matter and the information before the court is going to enter the following orders as to your case. The court is going to order that you be released on your promise to appear at future proceedings. There are several conditions of release. These are fairly detailed, so I'm just going to review them slowly with you. You're not to possess or consume any alcohol or illegal beverages until further court order. Commit no acts of domestic violence, and also not to possess any firearms or weapons. And this is where it gets a little bit detailed, so I'm going to, if you need me to repeat this, let me know. You're not to have any contact with the individual Christian Anaya, except through a third party to coordinate contact with your child in common. Additionally, you're not to go to Mr. Anaya's residence or workplace unless it's part of an exchange of the child in common, but you're not to have any contact with Mr. Anaya within 10 feet, not to go within 10 feet of him until further court order. And if you do share this residence with Mr. Anaya, then you can return one time with law enforcement to get your belongings. Do you have any questions about those release conditions?
No, sir.
In that case, then we'll set your next hearing in this matter, April 8th, 2025, 1:30 p.m. with Judge Millian at the Tucson City Court. Make sure that you appear at future hearings. Failure to appear can result in a warrant being issued. Do you have any questions?
No, sir.
Then you're all set. Thank you, ma'am.
Thank you.
Ruiz?
Oh, let me, before we proceed with Mr. Ruiz, Mr. Silva, I believe, did we have a hold on him?
We did, Your Honor, Superior Court hold.
Oh, okay. So if we can bring him back, ideally after, we get him back after Mr. Ruiz, then we'll have to inform him about that. Thank you. Okay, so Mr. Ruiz, can you please identify yourself first and last name? So Mr. Ruiz, we have you here today for a failure to appear. It looks like it's sentencing on some cases in 2024 for possession of prescription drugs and drug paraphernalia. So you do have a right to remain silent. Anything you say can and will be used against you. In order to secure your appearance at future proceedings, the court will set bond in this matter, $250 cash or secured. Court will appoint the city public defender's office to represent you. And also any prior release conditions will be affirmed. Your next court date in this matter will be on March 21st, 2025 at 1:45 p.m. And that'll be with Judge Maldonado over at City Court. And so if you do end up posting bond,
Silva.
and this is where we could do an outdate if he does post. If you end up posting bond before your video review on March 21st, you would have an alternative court date, which would be April 10, 2025 at 9:30 a.m. If you are still incarcerated at the time of the video review, however, you would be presented for that, made available for that at the city court. Do you have any questions, sir, at this time?
No.
Okay, then you're excused. Thank you, sir.
Your Honor, Mr. Silva went to the bathroom.
So we just bring him back maybe before we start with the felony cases? Before we can maybe do Mr. Sanchez, but after that, bring him in?
That's fine, Your Honor. Let me get Mr. Sanchez and we can still see Silva.
Okay. Or if you want to wait, I know we have to do Mr. Sanchez separate. You want to just wait for him to finish and then bring in Mr. Silva?
Don't know how long they'll be, sir. It's probably more efficient to do Sanchez.
Okay, let's do that.
Okay.
You want Silva's back?
Yes, please. Okay, good morning, sir. Can you state your name, please?
Xavier Lewis Sanchez. Good morning, Your Honor.
Mr. Sanchez, we have you here today. And do we have anybody else in the room?
No.
No, the defendants. Okay, so Mr. Sanchez, you're and Mr. Zarzicki, do you want me to waive reading on this, or what would you like?
Yeah, that's fine.
Okay, Mr. Sanchez, you're here on two class 2 felony counts your defense counsel has waived reading as to the actual charges. If you need to review those charges before we finish today, you're welcome to confer with counsel about that. As to the pending charges before you, we have bond being requested by the state in the amount of $180,000 with release to pretrial services if bond is posted. Mr. Terrace, any additional record?
No.
Okay. And then Mr. Zarzicki, any record on behalf of the defendant?
Judge, obviously this is a hard case given the nature of the charges. I will note that largely, at least based on the interview we have so far, largely the state's case is based on the statement of the victim. Basically, that's the entirety of the case. Not here to litigate the nature of it, but needless to say, it might not be as severe as the interim complaint indicate. Bottom line, as far as his background goes, I mean, he has no priors prior to this. He's, with but for the nature of the charges, he's a level 1 offender. He does have some history of mental health and substance abuse issues. Given his age, Your Honor, I do strongly suspect that mental health issues might be exacerbating, as they tend to with people in their early 20s. I would obviously, if the court is willing to entertain a release to pretrial services, we would happily, and he would happily abide by any conditions that the wants to impose. Barring that, we would ask for a more reasonable bond amount. The $180,000 suggested by the state is akin to a no bond. We'd ask for something more than $50,000.
Okay. At this time, the court will step on in this matter. The amount of $50,000 cash is secured with release to pretrial services if bond is posted. Additionally, the court will enter the following conditions of release. And the court will just indicate that part of the reduction of bond is in part because even though there is a victim in this matter, this is a severe charge, that it doesn't appear that there is a set of victims or more than one victim, which does, I think, reduce the danger that the defendant poses, but there's still danger that is posed to the community that necessitates a bond being set in this matter. Conditions of release if bond is posted to follow because they'll be released to pretrial services, monitoring and treatment as directed by pretrial services. Additionally, that the defendant is not to have any contact with the alleged victims. If there's a shared residence with the victim, may return with a police escort to pick up belongings on one occasion. And additionally, the defendant shall not go to the victim's residence or workplace. As an additional condition of release, no contact with any children until further court order. The counsel is appointed in this matter, Pima County Public Defender's Office. Next hearing date for Mr. Sanchez, March 24th, 2025, 1:30 p.m. That is for preliminary hearing at the Justice Court. Mr. Sanchez, if you are still incarcerated at time of future hearings, you'll be made available. But otherwise, if you are released and do post bond, you need to make sure to go to future hearings. Failure to appear can result in a warrant being issued. Any questions at this time?
No.
Okay, then you're excused. Thank you, sir.
Your Honor, if I may, good morning. This is Spanish court interpreter. Just making sure there's no Spanish speakers.
I think we're all good. You can be excused.
Thank you so much. Have a great day.
You too.
Bye-bye.
This is Mr. Silva.
Hi, Mr. Silva. Welcome back. Sorry for the mix-up. So the court observed that you have what's called a superior court hold, which means that even if we tried to release you on today's date, they wouldn't actually to at least try to give you some an opportunity to get any sort of necessary time credit on anything that's pending right now. The court is instead going to set bond in this matter as to all pending charges in the amount of $50 cash is secured. And the court will appoint the City Public Defender's Office to represent you. Once that hold is lifted by Superior Court, you should be able to post bond and be released, but just confer with your public defender more fully about that. So we had to just inform you that that's what's going to happen. That's why we had to bring you back today. The court will set a video review in this matter March 21st, 2025, 1:45 p.m. with Judge Cranshaw to check in on things. So with those adjustments, any questions, Mr. Silva, at this time?
No.
Okay, then you're excused. Thank you, sir. Nice.
Middle. All the way around to this. Way down, way down. Say more about please, sure. It's called chair.
Good morning, ma'am. Can you state your name, please?
Kimberly Baltierra.
Ms. Baltierra, you're here today on a couple of felony charges, possession of a narcotic drug, possession of drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and there is counsel seated next to you to assist you. The state is recommending bond be set in the amount of $7,500 with release to pretrial services if bond is posted, and that this is also in lieu of requesting no bond. Any additional record, Mr. Terrace?
Judge, the state would like to amend the recommendation to release to pretrial services.
Okay, and then Mr. Zarzicki, any objection to that?
Obviously not. I appreciate it.
Okay, in that case, then, Ms. Baltierra, it looks like the state is giving you a gift today. They're not requesting that bond be set. They're going to order, they're recommending that you be released to pretrial services. The court's inclined to go ahead and do that then, if that's their recommendation. So you are going to be released on today's date to the third-party supervision of pretrial services. You need to make sure that you follow up with pretrial services as soon as possible. That's a way that we see people often fail when they're released, is if they fail to check in with pretrial services, and then a warrant's issued for failure to apply. So make sure that you check up with them. You'll get their information before you leave today. You're not to consume or possess any alcohol or illegal drugs. Court will appoint the Pima County Public Defender's Office to represent you as well. And so then your next court date then is going to be April 1st, 2025, 1:30 p.m. for a preliminary hearing at Justice Court. Since you're being released today, that hearing may be moved. And so just check with your public defender about when that next hearing is going to be set in your case, okay?
Yes, sir.
Any questions at this time?
No, sir.
Okay, then you're excused. Thank you very much.
Thank you. Thank you.
Basera.
Okay, good morning, sir. Can you state your name, please?
Juan Carlos Becerra.
Mr. Basera, you're here today on, let's see, a couple of matters. We'll take them one at a time. First matter we're here for today is for felony charge of theft of a firearm. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There is counsel seated next to you to assist you. State is requesting bond be set in the amount of $2,500 with release to pretrial services if bond is posted. Mr. Terrace, any additional record?
Your Honor, the state is going to keep the recommendation. I will just note that in the recommendation, it says that the defendant is facing mandatory prison time if convicted. And the state would like to correct that and say that he is not. He would be probation available at trial.
Okay, thank you. And then Mr. Zarzicki, any record?
Yeah, I want to make a record on a couple things. First off, as to the probable cause of this, and I understand this is probably more a trial or more directly a pre-trial issue. But I do think there's some weakness in the state's statement. So he was discovered in a vehicle. So first off, he was discovered in a vehicle. The gun was then discovered pursuant to a quote unquote Terry frisk of the vehicle, which is not a thing. That's not legal. There is no such thing as a Terry frisk of a vehicle. But additionally, the gun was discovered under the seat. He denied any knowledge of it. It was never in his actual physical possession. There's obviously no forensics to tie it to him, etc. So I do want to point out some of the weakness in the state's case. Regardless of whether or not that's enough to establish probable cause, I think it does go to the limited culpability here. Mr. Basera is a full-time college student, lifelong resident. He has confirmed residence with his mother. He has absolutely no priors. He's a level 1 assessment, nonviolent felony. We would ask for release from trial services.
Any additional record, Mr. Terrace?
No, Your Honor.
Okay. As to the theft of a firearm charge, the court is going to order releasing the defendant to the third-party supervision of pretrial services over the objection of the state. Court will order as conditions of release, no possession of firearms or weapons by Mr. Basera. Any firearms in your possession shall be surrendered to law enforcement. Follow monitoring or treatment as directed by pretrial services. Court will order that the Pima County Public Defender's Office is appointed. If not already stated in my signing off on the complaint, the court will find, however, probable cause to proceed on this current charge. And Mr. Basera, if your appointed counsel may be able to make something happen with that at a future hearing date, but the court is going to go ahead and preserve the charge for the time being, based upon the information before the court. Since you are being released as discharged, preliminary hearing is set April 1st, 2025, 1:30 p.m. That hearing date may be moved. That would have been at the Justice Court. That hearing date may be moved because you're being released on this. So check in with your public defender about your next court dates to make sure you don't miss a court date. A warrant can issue for your arrest if you fail to appear at future court dates. So that is the first thing we have to see you for today. Second matter is some additional charges regarding, give me one moment, reckless driving, having a concealed weapon without a permit, and failing to admit carrying a deadly weapon, which are misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. And then, Mr. Zarzicki, this is on the misdemeanor. It doesn't technically have right to. Mr. Terrace, do you have any objection if I inquire with Mr. Zarzicki on this, or would you prefer we just proceed without that advice of counsel?
No, Your Honor, no objection.
Mr. Zarzicki, is there anything that you want to say about these charges, just to give you an opportunity?
I would reaffirm, it looks like they probably arrived on the issue, so I would just reaffirm what my stated position before. It does not look like this is anything more serious than what we've already dealt with, and he does have confirmed residence.
And so what the court's going to do then is court will, on these specific charges, the court is going to order Mr. Basera that you be released on your promise to appear at future proceedings. Your next court date in this matter is March 24th, 8:30 a.m. at the Justice Court for an arraignment. So that's going to happen. That's going to be your first hearing as to your pending charges. There are several conditions of release. You are not to drive without a valid license, no alcohol or illegal drugs. Actually, no, I'm going to take off alcohol or illegal drugs. I don't think there's any mention of use of alcohol or illegal drugs. However, the court is going to affirm no firearms, surrender any firearms, as well as additional conditions. Next court date, March 24th, 8:30 a.m. as your next court date. Do you have any questions at this time, sir?
No.
Okay, please make sure that you follow up with pretrial services for the felony offense and that you go to future dates. Critically important. Court's giving you a chance here, so don't make the court look foolish, okay?
Yes, Your Honor.
Okay, then you're excused. Thank you, sir.
Thank you. Have a good day.
Defender, you're up.
Can I have a seat? Can I go in person?
No,
Your Honor?
sit down.
Can I appear in person, please?
Mr. Bender, the court's going to deny your request for an in-person appearance at this time without prejudice.
Can I have the green screen removed so my people are behind me, please?
The court will also deny that request, sir. Go ahead and hold your comments for right now. If you need to confirm
Bye.
with counsel,
Bye, sir.
we'll give you that opportunity. So, Mr. Bender, you're here today on a charge of burglary in the third degree unlawful entry. It's a class 4 felony. You do have a right to remain silent. Anything you say can and will be used against you. And you do have a right to assistance of counsel. And in this matter, the state has a bond recommendation, which is for $5,000 plus release to pretrial services if bond is posted. Mr. Terrace, any record on that recommendation?
Your Honor, this,
Oh, I'm sorry.
Mr. Bender, please do not interrupt. Go ahead.
Your Honor, the state is concerned given his lack of ties to Tucson. He does state that he lives in Globe. He is on probation out of that jurisdiction for a similar offense. He was also charged with burglary third degree in that case.
Thank you. And then Mr. Zarzicki, do you want a moment to speak with the defendant before we proceed?
Yeah, that'd be great, Your Honor. Let me mute this real quick.
Your Honor, please, I don't want to talk to a lawyer anymore. They've screwed me so bad already in the last year or two. I already have ethical concerns with the two lawyers up in Globe. It's already been filed on the court that it's ethical concerns. And they were discussing evidence freely on both sides in my private matter with my ex. These lawyers need to get out of my life. I need to just talk to you. That's it. I don't need to talk to the lawyers anymore. You need to leave.
Okay. At this time, the court was going to, Mr. Zarzicki, any record that you want to make?
The one thing I have an inquiry about, Your Honor, is and I don't know if the jail staff might know, is there a hold on him out of Gila County yet? Okay.
I'd request to be transferred up to Globe if you want me to hold out there. But I would like to see Judge, I think it's Judge Wright. Not the old guy, the younger one with the black hair.
Let me just confirm something really quick, Mr. Bender. Jail, is there a current hold out of another jurisdiction?
You're not showing when you're there.
Okay. Anything else, Mr. Zarzicki, before we proceed?
I'll just note, since he doesn't have a hold out of Gila County, that that is the one reason I'd ask for release, so that he can deal with his probation case. Deal with his stuff here, then go up and deal with his probation case. Assaulted for in court.
I do not have transportation up to my home or a phone. So it's going to be impossible to find my way there. I've tried for 2 or 3 days. My feet are beat to shit. I've been walking like 500 miles, 600 miles in a couple of days just to get home.
So, Mr. Bender, at this time, court will just request respectfully that you hold any additional comments at this time. I'll ask you if you have any questions at the end. The court at this time will order that bond be set in the amount of $1,500 cash and secured with release to pretrial services if bond is posted. Court will further order its conditions of release not to go back to the incident location, not to have any contact with any alleged victims relative to the offense. Court will order the Pima County Public Defender's Office to be appointed to represent Mr. Bender. And then next hearing for Mr. Bender will be a preliminary hearing, March 24th, 2025, 1:30 p.m. at the Justice Court. And then the jail's not showing any holds at all, right?
No, you show.
Okay. And then, so Mr. Bender, at this time, do you have any questions before we conclude?
Just how do I get home?
I think part of the benefit of having a public defender appointed is that you can start brainstorming some of those issues with that public defender. They should be reaching out to you shortly as well. So at this point, then.
They did not try 1 second last time either. So no, I don't want a lawyer. I just want to go home. I just want to go home.
So the
It's what, like 100 miles from here.
So this time,
Take a ride by a cop.
So at this
Sure.
time, the court,
Right.
okay, go ahead, mute his line, please. Okay, so at this time, Mr. Bender, the court, in recognizing the alleged offenses, the court is setting bond to ensure your appearance and also based upon the alleged offenses. Speak with your public defender. If you don't wish to have counsel after that, I have an obligation to appoint counsel for you. It's a constitutional right that you have, and so that's why the court's doing that today. At this time, the court is going to conclude today's initial appearance. You're excused. Thank you, sir.
You got it.
Okay, good morning, sir. Can you state your name, please?
John David Bowman Jr.
Mr. Bowman Jr., we have Couple of matters we're seeing you for today. We'll take them one at a time. First matter I see that is before us, it looks like it's a couple of warrants that were issued for failure to appear. Let me just pull up something really quick and we'll go ahead and proceed. Okay, so we have a couple of warrants that were issued, sir. There was for a criminal failure to appear in a criminal trespass matter, failure to appear occurring on or around January 2nd, 2024. And then a warrant was issued. Additionally, you were to appear at the Superior Court on updated charges of drug use, dangerous drug use, narcotic possession, 2 counts, and a drug paraphernalia violation. You do have pending felony charges. You do have a right to remain silent. Anything you say can and will be used against you. And the warrant as well was for failure to appear on trespass. So we have a couple of failures to appear that we're trying to address on today's date, and they're in different jurisdiction. One in Superior Court, one in Superior Court. State is recommending, I believe Mr. Terra says, to the failure to appear on the drug offenses in Superior Court that bond be set in the amount of $7,500 plus release to pretrial services. Any additional record?
No, Your Honor.
Okay. Court will note there looks like a 6 and a 6 on the NCA and FTA scales as well, noted by pretrial services. The assessment does indicate prior history of failure to appear despite being provided actual notice of the proceedings. Mr. Zarzicki, any record as to the warrants?
Yeah, I'll just note, Judge, I know given the level 4, 6 and 6 recommendation, the court is probably strongly disinclined to release to pretrial services. Obviously, if the court was willing to do so, we would advocate for that. What I will point out, though, however, is there's an arraignment no-show from last month is the only issue in this case. He is a lifelong resident. He only has 1 prior felony case. Both that case in this case were not offenses. If the court is not inclined to release to pretrial services, given his current economic situation, pretty much is going to be akin to no bonds. But we'd ask for something like the other 1,500 to at least give him some realistic possibility of posting bonds.
Okay. This time, as to the Superior Court failure to appear, the court has been ordered setting bond in the amount of $1,500 cash if secured with release to pretrial services. If bond is posted, condition of release will include to follow monitoring or treatment as directed by pretrial services. Any prior release conditions for these charges are affirmed, and Mr. Bowman is directed, if he is released, to contact pretrial services on the first business day following his release. Pima County Public Defender's Office is appointed to represent Mr. Bowman. There's an arraignment onto these pending these various felony drug charges at the Superior Court. It's going to be March 19, 2025, 1:30 p.m. For an arraignment. Mr. Bowman, if you're still incarcerated at that time, you'll be made available virtually for the arraignment at Superior Court. And then at this time, we'll go ahead and go on to the misdemeanor matter for trespass. Since you are being held as to the other matter, the court is just going to set nominal bond in this matter as well, so you get any time credit as to the pending charges. That will be in the amount of $100 cash or secured. The court will appoint Mr. Gary Grinkwich to represent you on today's date in the misdemeanor trespass matter. Any prior release conditions for that matter are affirmed. And that court date for the Trespass and Justice Court, that is March 13, 2025, 1:00 p.m. for an arraignment with Judge Ball. And so, Mr. Bowman, you'll likely be, you may be incarcerated at time of that hearing tomorrow. Make sure that you appear at all future hearings. Failure to appear can result in a warrant being issued. Do you have any questions, sir, at this time?
No, sir.
Okay, you're excused. Thank you. Oh, you know what? I'm sorry. Let's get him back really quick. We have one more thing to address. Sorry, Mr. Bowman. We had also, there's some city court matters that you are here for. I imagine that's why the warrants came up, is because there were some shoplifting issues that were noted from looks like March 11th. So you do have a couple of misdemeanor charges: theft and drug paraphernalia, shoplifting and drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. At this time, the court is going to, because you're already being held on the other matters, the court will set bond in this matter as to these charges in the amount of $50 cash or secured. Court will order appointing the city public defender's office to represent you. Order that you not go to the incident location relative to the shoplifting offense, and not to also just consume any alcohol or illegal drugs. Next court date in this matter is going to be a video review, March 21st, 2025, 1:45 p.m. for video review with Judge Maldonado at the city court. So that's an additional hearing that you do have for yourself as well. Okay, at this point then, we should be all set. Thank you, Mr. Bowman.
Thank you.
Good morning, Neil Poston for the state.
Okay, thank you, Mr. Poston.
Forgive me, I was in, of all places, juvie court doing a restoration rights hearing that I had to be present.
Okay. Thank you for appearing. Mr. Terrence was able to amply cope. Okay. We'll go ahead and proceed then. Mr. Brown, is that you?
Yes, sir.
You're going to identify yourself first and last name.
Quincy James Brown.
Mr. Brown, you're here today on a couple of matters. We'll take them one at a time. First matter that we'll discuss is we have possession of our narcotic drugs for sale of a narcotic drug, and possession of drug paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. And you do have a right to assistance of counsel. There is counsel seated next to you to assist you on today's date. State is recommending bond be set in the amount of $10,000 with release to pretrial services if bond is posted. It appears we also have a DOC hold on you at this time. Is that correct, Jail?
Yes, Your Honor, that's correct.
Okay. And so what that means, Mr. Brown, is even if the court was inclined to release you on today's date, the Department of Corrections has placed a hold on your file essentially so that you would not be able to be released until that's resolved. But the state is recommending $10,000 with release to pretrial services. Any additional record, Mr. Poston?
Your Honor, I do show his our administrator had us do two recommendations. It looks like
I only have one in the court file right now. Is that something maybe you can send over to the initial appearances email?
I did, but I'll send it again.
Okay. Did we happen to have a second? Do we have a second one for them, the second recommendation?
Oh, good. So let me get it. And then we talk about it.
And
he hasn't given me a preference.
I'm sending it presently, Judge.
Okay, we'll wait to get
Sent.
that before we proceed.
I just sent it now.
Thanks. And then, Mr. Zarzicki, do you want to speak with Mr. Brown any further? We've got a little bit of time.
I do.
Oh, okay, it's not come through. Okay. Yeah.
Did you receive it, Your Honor?
We just got it.
Thank you.
Okay, thank you. Okay, Mr. Zarzicki, let us know when you guys can jump back on.
So here's where we're at, Your Honor. And let me, hold on, this is gonna pull up the hearings here. I'm reviewing the second recommendation. So I'm not entirely sure why there's a second recommendation on this case. I'm not sure which one you're dealing with.
Mr. Poston, is the second recommendation as to the unlawful flight?
Yes,
Gotcha. Unlawful.
there are two different dates on the felony charges, and this is for the subsequent date.
Understood, Your Honor. All right, so let me address a couple of things then. We have, and hold on, let me bring up the real quick. So first off, Mr. Brown wanted to make clear that he very much contests the charges on this case. And let me check what the state's alleged as far as the actual basis goes. But essentially, this sounds like, even if we take the state at its word, the worst case scenario under this complaint, this sounds like sort of the typical case where we have somebody that was busted with a large amount of drugs and the state just presumed under the statute sales. He fully contests that he was selling drugs. We won't speak as to the possession on that, but he definitely contests he was selling. As to the parole hold out of Gila County, we would ask that he be released so that EOC can pick him up and can finish out his time. He indicated that if he does indeed, if he can kill his number, he should be done in April anyway, so that he can be released and come back down here and deal with these cases after he's killed his time.
Any additional record on this first set of charges, Mr. Poston?
None.
Okay, at this time, court will, is ordered setting bond in this matter, $10,000 cash is secured with release to pretrial services. The bond is posted. Additional conditions of release and follow monitoring or treatment is directed by pretrial services, no alcohol or illegal drugs. Go ahead and mute the line, please. Okay, counsel is appointed Pima County Legal Defender's Office to represent the defendant. Next court date is going to be preliminary hearing, March 24th, 2025, 1:30 p.m. at the Pima County Justice Court. So that will be what we do for that one. And then we're going to go to the next issue, and that's going to be the unlawful flight. State has recommended bond be set in the amount of $2,500 plus release to pretrial services and bond that would be consecutive. Any additional record, Mr. Poston?
No, Your Honor.
Then now, Mr. Zarzicki, if you want to go ahead and unmute, any additional record on the unlawful
I
flight?
will. Yeah, I'll definitely make a record on that one, Your Honor. He is homeless. He is unemployed. That $10,000 bond is a no bond for all intents and purposes. We don't need to stack $2,500 on top of it. So we're asking for not release, but either a nominal bond or I don't know if the court can technically order a concurrent bond. I guess since they're both pre-indictment, the court can. So we'd ask for either concurrent bond.
And are these
Please.
are these both with the Justice Court? Oh, they are. Okay. Okay. All right. At this time, the court will order setting bond in this matter, $1,000 cash secured. Court is going to I'm going to leave it as consecutive under the circumstances. Court will order that the defendant not drive without a valid license. Counsel is appointed in this matter. That will be John Illis to represent the defendant. Next court date, March 24th, 2025, 1:30 p.m. for a preliminary hearing. And then, Mr. Brown, make sure that you appear in future proceedings. Failure to appear can result in a warrant being issued for your arrest. And at this time, the defendant is excused. Okay, good morning, sir. State your name, please.
Justin Davis.
Mr. Davis, we've got you here on a couple of matters. We'll take them one at a time. First matter we're here for is a charge of possession of a dangerous drug, possession of paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. Counsel is seated next to you to assist you. State is recommending bond be set as to these charges in the amount of $7,500 plus release to pretrial services. And then any additional record, Mr. Poston?
No, Judge.
Mr. Zarzicki?
Judge, I'll note the charges on this case are invalid and relatively minimal. We're talking regular third and existing arrest. Obviously, we are talking about a long period during which he was on warrant status, and we're talking about some scores here. That being said, though, he is a lifelong Tucson resident. His sister is in town, is verified his residency, offered to provide support, transportation for him. And I mean, not to be glib on this, but he was in warrant status for a long time, and the fact that he wasn't picked up on new charges during that time, it's a bit of an outlier that kind of indicates that he's probably doing better, all things considered. So given that he has not picked up new charges since he's been in warrant status on this, prior to now, and given the support that he has in town, we ask the court to consider release pretrial services, barring that
Let me check on something really quick, just one moment. I know. All right. Okay, so we had a little bit of a mix-up, paperwork out in the wrong file, so that's our mistake. So, Mr. Davis, to correct, you're not here on possession of dangerous drug and drug paraphernalia. It's a different defendant we have today. You're probably a little bit confused about that. Not what you're here for today. So we just have you on a couple of warrants for failure to appear. That's all we have you here for today. And then with that clarification, does anyone else, any counsel want to be heard before court makes a ruling?
No, Judge.
No, I'll stand there as soon.
Okay. Right. Okay. In order to ensure appearance for the failure to appear, the court will set bond in the amount of $1,000 cash is secured to the Superior Court matter with release to pretrial services if bond is posted. Court is going to appoint Sarah Wright to represent the defendants. Prior release conditions are affirmed, and defendant, if he is released, is to contact pretrial services on the first business day following release. Next court date for Mr. Davis, criminal arraignment, and that's going to be at Superior Court, March 19, 2025, 1:30 p.m. So do make sure that you appear. If you are still incarcerated, you'll be made available by video for that arraignment. And so that's as to the Superior Court warrant. As to the Justice Court warrant, because you're already being held on the other warrant, the court's just going to set additional bond in the amount. This is to secure appearance. $250 cash is secured. And Gary Grinkowicz is appointed to represent you in that matter. Next arraignment, next hearing is an arraignment tomorrow, 1:00 p.m. So that's March 13, 1:00 p.m. at the Justice Court with Judge Ball. And do make sure that you appear at that as well. Even if you do post bond on today's date, failure to appear can result in a warrant being issued. Any questions, Mr. Davis, before we conclude?
No.
Okay, you are excused. Thank you, sir.
Jason, good morning.
Okay, good morning, sir. Can you state your name, please?
Jason Devine.
Mr. Devine, we've got you here today on two counts, two charges, one for possession of a dangerous drug and then one for possession of drug paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You have a right to assistance of counsel, who is counsel seated next to you to assist you. The state is recommending that a steps hearing be set for you, and I'll explain what that is. And additionally, that you be released to the third-party supervision of pretrial services. Any additional record, Mr. Poston?
No, Judge.
And then, Mr. Devine, let me just briefly explain what the steps hearing is. That's a hearing where you'll be collaborating with the Pima County Superior Court on a diversion type program. And if you meet all requirements for that program, their charges may be dismissed as if they were never actually filed in the first place. And so is that something you want to avail yourself of?
I think so. Yes, sir.
Mr. Zarzicki, did you want to make any additional record?
No,
And would the defendant waive time as to setting the steps hearing?
we'll waive time for the steps.
Okay, so at this time then, the court will order releasing the defendant to the third-party supervision of pretrial services. Mr. Devine, the court is going to order, though, that you follow monitoring or treatment as directed by pretrial services and no consumption or use of alcohol or illegal drugs. Legal Defender's Office is appointed to represent you. Will set your next hearings as follows. You have a steps hearing at Superior Court, March 19, 2025 at 9:00 a.m. at Superior Court. Additionally, your preliminary hearing as to the underlying charges, April 28th, 2025, 1:30 p.m. That'll be at Justice Court. And so since you're being released, that hearing may be moved. That date might be moved, but just check in with your legal defender. They can clarify all dates for you. Do you have any questions at this time?
I do not.
Okay, then you will be released today as indicated and you are excused. Thank you, sir.
Thank you. Judge, I'm going to write him a little reminder right now, just in case. It was March 19th at 9 a.m.
Yes, it is.
Okay.
So here's the phone number for premium services needed. There's your attorney's phone number to get in touch with them. And March 19th at 9 a.m. for insurance birthday.
Zachary? You're up.
Okay, good morning, sir. Can you state your name, please?
Zachary Devine.
Mr. Devine, we have you here today on a couple of matters. We'll take them one at a time. Number one, we have that you were picked up on a fugitive warrant out of the state of Utah. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There's counsel seated next to you to assist you. Okay, so the state is recommending that bond be set as to the warrant. I know we had a spirited discussion yesterday about another case. The court's inclined to hold the defendant without bond pursuant to the statute, but Mr. Poston, any record?
The court summed it up accurately, Your Honor. No.
Okay. Mr. Zarzicki, any record as to that before we go to the city court matter?
What's the legal basis for holding it that matter?
Under ARS 13-3856, the defendant is alleged, let me see if I can pull up the information, but there's a fugitive warrant that was recognized, and that is for out of the 2nd District Court of Ogden, Utah. There was a forgery charge and a warrant was issued. And so under 13-3856, and also under the interstate compact that exists between the states as to these fugitive warrants, that the information before the court is that the on release following a conviction that the defendant
Conviction.
What?
This is a pre-conviction warrant.
He's correct, Your Honor.
Oh, it's pre-conviction.
It is
Yes.
pre-conviction.
Oh,
The
okay.
state- Upon further review, the state would recommend the $5,000 bond, which is the The amount that the Utah court implemented.
Okay, and then Mr. Zarzicki as to the amount of the bond.
We're asking for the lease. He's a 1-on-1 on the scale. He's been a resident for 3 years, stable resident for 3 years. He has no priors prior to this. We're asking for him to be released so he can return to Utah and deal with it on his own.
Please, please, please.
Mr. Zarzicki, can you discuss with the defendant and then articulate after that discussion, what's the game plan for doing that?
Can do, Your Honor.
All I'll say, Your Honor, is it is a extraditable warrant, which speaks to Utah wanting him quite badly.
All right, Your Honor, first follow up on what Mr. Poston said. It's a non-violent crime. It's forgery. It is an extraditable warrant, but every felony is an extraditable warrant. It's a 5K bond, so I would argue that Utah doesn't really like it that way. I did speak with him. His mom can provide him transportation back to Utah. He said he can do it within the next week. So we would ask for release and set a review hearing on the status of the warrant in a couple of weeks. And he'll get able to get taken care of.
So the next hearing that would be set on this would be a warrant hearing on the 17th next week. So that's the court's inclination, is to set it as the warrant review at that time.
And he'd be amenable to that for sure.
What is the name of the defendant's mother?
What's your mom's name?
My mom's name is it's Tammy Ryan.
And can you spell her first and last name?
Yeah, it's Tammi Ryan, Ryan, and she's of Brigham City, Utah.
Oh, she does not live here in Arizona.
That's correct. She lives in Utah.
So she would be coming down to take him back.
Yeah.
Okay. At this time, what the court's going to do is the court's going to order releasing the defendant to the third-party supervision of pretrial services. The court is going to appoint the Pima County Legal Defender's Office to represent the defendant. Court is going to order Mr. Devine that you appear in person at an arraignment. I'm sorry, at the fugitive warrant hearing, which is going to be set March 17, 2025, here in the Pima County Superior Court. So if you're going to take care of the warrant in Utah, you're going to have to wait until after that hearing, unless you can make it up to Utah and get back before. A warrant will issue for your arrest if you're not present in person at the arraignment on March 17. I'm frankly a little bit confused about what's happening in this particular case. Normally, we hold folks without bond on these issues, and there's not really an argument as to that. I'm not really sure, but under the circumstances, I'm just going to order that you, as a compromise, that you appear in person.
Thank you.
Okay, Mr. Poston, did you want me to indicate that over the state's objection?
Yes, please.
Okay, court will further indicate that the ruling on today's date is over objection of the state. And so then again, the next hearing, March 17, 2025, 2:30 p.m. That's when you need to appear at the Superior Court. So make sure that you appear at that, Mr. Devine. We have one other additional matter to address for you today. And that's going to be a city court matter. It's probably why the warrant came up in the first place. You have a pending charge of
Yes.
drug paraphernalia. It's a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. Court at this time is going to release you on your promise to appear at future proceedings. Your next court date in this matter as to the drug charge in city court is going to be April 10, 2025, 9:30 a.m. You're not to possess or consume any alcohol or illegal drugs for the duration of this case. And any questions before you're excused for today's day?
Not for me.
Okay, all right, then you are excused. Thank you, sir.
Thank you so much. I appreciate it. Thank you. The lawyer ASAP and make sure you make that. Okay, all right, perfect. And I'll be here for yep, the back for April 10th. Yep, and that's the city. Okay. So the address is right there. So thank you so much. Thank you. Thank you, Your Honor.
Morning, sir. Can you state your name, please?
Keith Richard Gonzalez.
Okay, Mr. Gonzalez, you're here today on, it appears, failure to appear on some prior offenses from December 2024, felony offenses of possession of a dangerous drug, possession of a narcotic drug, and drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. Counsel is seated next to you for your assistance. Let me just review something really quick before I make a record as to this recommendations. Okay, the state is recommending bond be set in the amount of $2,500 plus release to pretrial services. Any additional record, Mr. Poston?
Nothing further, Your Honor.
And Mr. Zarzicki?
Judge, this is one of these cases which, quite frankly, really annoying me. He was not initially arrested on this case. There was an indictment followed by direct summons that was mailed to him. Frankly, the fact that mailing is acceptable as a way to summon somebody for a criminal charge is the annoyance that I have. If this were a civil case, he would have to be served in person, yet somehow it's acceptable just to send him something in the mail and expect him to show up. He indicated he never got the summons. Quite frankly, given the nature of the U.S. mail right now, I think that's highly possible. Additionally, he scores a 2 and a 3 on the scale. He has 1 nonviolent drug prior from 2009, lifelong Tucson resident, has employment as a drywall repairman. I don't think there's any reason to believe he's a threat to the community. And as far as his failure to appear on this case, like I said, given that he was never even arrested in the first place, there was a direct indictment and then a summons that he never got. I don't see how he had any notice to actually be at it. So we would ask that he be released to pretrial services.
I tend to agree. This doesn't appear to be one of those situations where we have a defendant who was released at an initial release to pretrial. They don't show up. They got notice. So I think there could be some notice issues here. For those reasons, the court will order releasing the defendant on his promise to appear at future proceedings. And let me indicate, so the court is going to appoint the Pima County Public Defender's Office to represent the defendant. As a condition of release, Mr. Gonzalez, no alcohol or illegal drugs until further court order. Your next court date is an arraignment, March 19, 2025, 1:30 p.m. at Superior Court. You didn't show up at the last one. There may have been a notice issue. There's not a notice issue any longer. You have notice today of when your next court date is. That's going to be a week from today, 1:30 p.m. At the Pima County Superior Court, probably on the 3rd floor, but double check it when you get to the courthouse. Failure to appear can result in a warrant being issued. And then if we're having to do this process all over again, the court may just end up holding you to make sure that you get to the court date. Does that make sense?
Yes, it does.
Any questions at this time?
No.
Okay, you're excused. Thank you.
Sure.
Brad?
All right, good morning, sir. State your name, please.
Stephen Grove.
Mr. Graham, we have you here today for a couple of felony charges for possession of narcotics and promoting prison contraband. We have another set of city court matters we need to address next, but as to these felony offenses, you do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and counsel is seated next to you for your assistance. The state in this matter is recommending bond be set in the amount of $7,500 plus release to pretrial services if bond is posted. Any additional record, Mr. Poston?
No, Your Honor, other than noting the hold that he has.
Okay, and can the jail confirm, do we have a felony hold or superior court hold?
APO.
Showing Superior Court, Your Honor.
Report, probation?
Yes.
Okay, thank you. So, Mr. Graham, what that means is that regardless of what the court's decision would normally be regarding release, there is a probation hold, so the court is not able to fully authorize release on today's date, so we need to talk about what type of bond is going to be set. State's recommending bond in the amount of $7,500. And then, Mr. Zarzicki, anything on behalf of the defendant?
I'll just note, given his financial circumstances, he's unemployed. He says is struggling some stuff. In addition to the fact that already is probation hold we asked for.
This time, court will set bond at the amount of $1,000 cash secured with release to pretrial services. If bond is posted, court will order no alcohol or illegal drugs for the defendant, and Mr. John Illis is appointed to represent the defendant. Next court date as to these felony charges is going to be March 24th, 2025, 1:30 p.m. at the Justice Court for preliminary hearing. The court is going to move now to the city court offenses that we have. So Mr. Graham has a wide array of failures to appear for city court charges. Court shows, I believe, 9 pending charges, or there are 9 pending with the defendant. In order to ensure the defendant's appearance at future proceedings in city court, the court is going to set bond in the amount of $1,000 cash or secured. Court will appoint the city public defender's office to represent Mr. Graham. And next court date for Mr. Graham is going to be as to these matters. That is going to be on March 21st, 2025, 1:45 p.m. for video review with Judge Hale. And any questions, sir, before we conclude?
What do I have new charges right now?
So yeah. Hold on 1 second. Let me mute it. I think we're good, Your Honor.
Okay, your excuse, sir. Thank you very much.
Thank you.
Roman Haynes.
Okay, good morning, sir. Can you state your name, please?
Kerwin-Ates.
Sorry, can you say that one more time?
Kerwin-Ates.
Okay, Mr. Haynes, you're here today on a charge of aggravated assault, domestic violence. This is a class 4 felony. You do have a right to remain silent. Anything you say can and will be used against you. Do you have a right to assistance of counsel? There is counsel seated next to you to assist you. The state is recommending bond be set in the amount of $35,000 with release to pretrial services if bond is posted. Mr. Poston, any additional record?
Your Honor, this involves a brutal assault with strangulation. The state need not remind the court of the statistics regarding lethality in cases involving strangulation. Defendant lives in New Mexico, has no reasonable contacts or ties to this community. And he, based on the narrative, he absolutely threw this person around like a rag doll after strangling her.
And Mr. Zarzicki.
Can I have a second to speak with him?
That's fine.
Your Honor, let me address one thing at a time here. So first off, as far as the underlying charges go here, obviously these are all allegations. The issue, the main reason this is a felony, in fact, the only reason I can determine that this is a complaint is the allegation of strangulation. Obviously, he disputes all of that. It does not look like there's really any evidence of that aside from the complaints of the victim. As to the state's contention that she was thrown around like a rag doll, again, the intercomplaint is she was pushed off. If we take everything that the officer says on his word, there was a strangulation. He was pushed off, and in the tussle that happened afterwards, he pushed her, and she fell onto the table. Again, dispute that all that happened. But worst case scenario, even if we take everything at face value in the complaint, there is a black eye. I mean, that is the sum total of the truth. As to the statistics of the lethality, blah, 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 that might apply to people in general. Mr. Haynes, however, has no prior criminal history. There's no allegations of prior domestic violence. Those statistics also require recurring patterns of domestic violence, which we don't have here. There is some concern about his residence. I do understand his only permanent residence is in Shiprock in New Mexico. I know this court might not be inclined to release him and allow him to return to New Mexico. We would ask for that. The court is willing to do that. Barring that, we would ask for a much lower bond, something more than $5,000.
So what's apparent from the complaint is that there were photographs of injuries that were sustained. So I think it goes just beyond mere statements. Second, the allegations implicate that the party's minor child had to watch the defendant attack his mother, and the court is concerned about that as well, and the trauma that that's going to inflict on that child. And the court has previously found probable cause on today's date as to the pending underlying charges. So, in order to ensure the defendant's appearance and based upon the severity of the allegations, the court is going to order setting bond in the amount of $35,000 cash is secured with release to pretrial services if bond is posted. Conditions of release include no alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons, and to surrender any firearms or weapons if any are possessed. Follow monitoring or treatment as directed by pretrial services. No contact with the victim, Jerry Garfield. Do not go to her residence or workplace. Pima County Public Defender's Office is appointed to represent the defendant. And next hearing is set March 24th, 2025, 1:30 p.m. at the Justice Court for preliminary hearing. Any additional questions, Mr. Haynes? Okay, then you're excused. Thank you, sir.
Desiree Montaño.
Good morning, ma'am. Can you state your name, please?
Desiree Montaño.
Ms. Montaño, we've got you here for a couple of matters today. Looks like we have some matters in Superior Court, failure to appear for City Court. We also have some City Court matters to talk about second, but we'll start with Superior Court. There is a failure to appear on or around January 7, 2025 relating to felony offenses of drug possession, dangerous drug possession, narcotic drug possession, and drug paraphernalia. So you do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. Counsel is seated next to you to assist you. Just take a look at one thing really quick before we get to the state's recommendation. Okay, yeah, it looks like you were arrested for the initial charges. You were released at the initial appearance and notified about, let me see. It's like a supervening indictment was issued. No contact with pretrial services. Okay. State's recommending that bond be set in the amount of $2,500 plus release to pretrial services. Any additional record, Mr. Poston?
No, Judge.
Okay. And then Mr. Zarzicki?
I did not specifically try to pull the information on this, but based off the timeline, this had to have been a dismissal. She was arrested on 9/23/24. A supervening indictment was mailed on New Year's Eve on 12/31. That's far too long of a gap. The state must have dismissed in the interim. Either that or at the legal so we don't go in their hearing set. It was after 12:31. Given that there was a dismissal in the interim, abdicated, or need to keep checking in with pretrial services. Obviously, she being arrested and having the initial clearance, she was on some degree of notice. But I think that is somewhat truncated fact pattern here. I'll point out she has no priors. I know based on the failure to appear history on both this case and the Tucson City for cases, the court's probably not chomping at the bit to let her out, but there are no priors here. She does have a legitimate reason why she would have missed this arraignment. She also had some additional hearings she was dealing with at the time.
Two different dates.
Got it. On two different listed dates. She was confused. Pretrial service was no longer involved once the case got dismissed. She is a lifelong resident. Her grandmother is willing to offer housing if she's released. We'll defer to the court. I would ask for release to pretrial services, and if not, I'd ask for, given that this is not a drug offense, bond around $1,500.
At this time, court is going to, in order to ensure the defendant's appearance, court will set bond in the amount of $500 cash and secured. That's the warrant amount that was issued back on January 7th. So that's $500 cash and secured. Court will order any prior release conditions are affirmed. Pima County Public Defender's Office is appointed to represent the defendant. Next court date for these charges will be the arraignment, March 19, 2025, 1:30 p.m. at Superior Court. Ma'am, are you listening? You'll have a chance to speak with counsel, but I need you to hear these dates. You have a substantial failure to appear history. That's why I'm holding you. I'm concerned if you're not listening, then you're not going to make the court dates again. So bond is set, $500, cash is secured. Pima County Public Defender's Office is appointed. Prior release conditions are affirmed. Next court date, March 19, 2025, 1:30 p.m. at Superior Court. You'll be made available virtually for that proceeding if you're still incarcerated. You need to appear even if you post bond. As to the city court matters, you have failure to appear on assault, disorderly conduct, and having an open container as a passenger. These are misdemeanor offenses. You have a right to remain silent. Anything you say can and will be used against you. As previously noted, substantial failure to appear history. You are being held on as this matter, so the court is going to ensure your appearance. Bond is set, $50 cash is secured for the city court matter. Prior release conditions are affirmed. City Public Defender's Office is appointed to represent you. And your next court date in this matter is a video review, March 21st, 2025 at 1:45 p.m. with Judge Cranshaw. And so those will be your next court dates and your excuse. Thank you, ma'am.
Paulson,
Walk the other way.
to your left, ma'am.
Good morning, ma'am. Can you state your name, please?
Christina Paulson.
Ms. Paulson, we have you here for a couple of matters today. We'll take them one at a time. First matter that we have you here for today on initial appearance, 2 felony charges, possession of narcotic drugs and possession of drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There is counsel seated next to you to assist you. Mr. Poston, let me verify what the state's recommendation is on this. There is a check mark for the steps hearing. Is bond being requested?
Your Honor, this person is a 6 out of 6 twice over, but for that issue, we would have immediately gone ahead and just said PTS with steps However, the state needs some sort of assurance in the form of a bond that she's actually going to show up, all things considered.
Okay. Mr. Zarzicki, any record that you want to make?
Yeah, I'm not sure. We're always at a loss on this because all we get is the final pretrial services thing, and despite all of the training that the pretrial services staff has been kind enough to give us on these, I'm not sure where the 6 out of 6 would come from. She has one theft prior from 2012. I would assume there's some failure to cure history. That would be the only possible thing. Aside from that, she's a 28-year residence. She has employment as a merchandise seller. She has a stable residence. This is entirely a drug possession case. There's really I don't believe there's any indicator of sales. She's been charged with sales. There were some drugs found allegedly in her purse, and that's the entirety of why she's here. She is an excellent candidate for steps. Again, I understand Mr. Poston's position. I don't understand where that 6 out of 6 comes from. We would ask the court to consider her releasing her to pretrial services and setting the steps here.
I think where it probably comes from is in looking at the prior history on the theft charge. We have failure to appear at sentencing, probation revoked, absconded from parole, and then having to do, so there's a lot of failure to comply here. I'm seeing a lot of failure to show up at city court matters as well, so there is a lot of concern there.
And I will just, that was my assumption as well, Your Honor. I'll just note that all of that stems from the case that's kept in all. So, as far as the politics, as to city court, I can't speak as much to that.
Okay. All right. At this time, over objection of the state, court will order releasing the defendant to the third-party supervision of pretrial services. Court will set. Ms. Paulson, we have something called the STEP program. It's a diversion program to see if you complaints missed. Would you like to avail yourself of that program?
Yes.
And is the defendant waiving time for preliminary hearing?
He is.
All right, so the court will order setting a stepped hearing in this matter, March 19, 2025, 9:00 a.m. at Superior Court for the stepped hearing. And additionally, preliminary hearing is moved out April 28, 2025, 1:30 p.m. As conditions of release, no alcohol or illegal drugs. You must follow monitoring or treatment as directed by pretrial services. And the Pima County Public Defender's Office is appointed to represent Ms. Paulson. Ms. Paulson, a lot of failure to appear. We're going to address some other failure to appear in just a moment. I am taking into account that the theft case did happen several years ago. The conduct that was alleged to have occurred happened over 6 years ago, the most recent instance. So I'm going to try to give you the benefit of doubt on the failures to appear, but I'm starting to see a pattern, and maybe I'm making a mistake here, but don't make me look foolish, okay?
Okay, Your Honor.
And so that'll be for the Superior Court matter. Let's go to, we do have a failure to appear for Injustice Court. That's before we get to the City Court matter. It's for failure to appear on shoplifting charge. The court is going to order releasing you on your promise to appear at that hearing. And the court is going to order that you not go back to the incident location for that shoplifting charge that previously was charged. You have a hearing for the shoplifting matter. It's on March 24th at 8:30 a.m. And that's a Justice Court. That's an arraignment with Judge Foster at Justice Court. So make sure that you appear at that as well. Mr. Zarzicki, I assume, is getting all these hearings written down for you.
What was the date on it?
March 24th, and that's 8:30 a.m. All right. And so lastly, we'll go to your city court matters. And this is, as we've indicated, failure to appear for criminal damage and theft. Court's going to give you one more opportunity, Ms. Paulson, to make good on your ability to appear at these proceedings. Court is going to order that you be released on your promise to appear. Who's going to set your next hearing as a pretrial hearing, April 10, 2025, 9:00 a.m. And that's with Judge Maldonado over at the City Court. So you've got a few court dates. Please make sure you keep track of all these. If you do not appear, a warrant can be issued, and the next judge who looks at this may not be as flexible as I am. Any questions at this time, ma'am?
No, Your Honor.
Okay, you are excused. Thank you.
Wilburn, wake up. Have a go.
All right. Good morning, sir. Can you hear the court?
Yes, I can.
All right. And can you go ahead and state your first and last name?
Daniel Thomas Wilburn.
Mr. Wilburn, you're here today on a few matters today. We're going to go ahead and take them one at a time. First matter we're going to talk about is some newer offenses regarding possession of a narcotic drug and possession of drug paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and counsel is seated next to you to assist you on today's date. State is recommending bond be set in the amount of $2,500 plus release to pretrial services. The court does note that you do have, is it a probation hold jail on the defendant?
Yes, Your Honor, it is.
Okay. And so, Mr. Wilburn, regardless of what the outcome would normally be today, the court is unable to fully release you on today's date because of the probation hold. That needs to get resolved. The state, though, as to bond, is recommending $2,500 be set for the bond. Any additional record, Mr. Poston?
No, Your Honor.
Mr. Zarzicki, any additional record as to this matter?
Judge, given the APO hold and given assessment of pretrial services, we'll defer to the state.
Okay. Court is going to, and this is in part based upon the hold existing, the court will order bond be set in the amount of $1,000 cash and secured with release to pretrial services if bond is posted. Additionally, court will order no alcohol or illegal drugs, and the Pima County Public Defender's Office, contract attorney is on this one. So we'll go ahead and do Mr. Illis on behalf of the defendant for this matter. Oh, I'm sorry. I take it back. We have another matter that I see we're here for with Justice Court. Let me check on something really quick. Okay. All right. Yeah. So Mr. Illis is to represent the defendant as to this these drug charges. No alcohol or illegal drugs as a condition of release. Next court date for these charges is going to be March 24th, 2025. It's going to be at 1:30 p.m. at Justice Court. And we'll go ahead and move on to the next matter, which is a failure to appear for DUI charges from 2021. At request of Judge Foster, court is going to set bond in the amount of $2,499 cash is secured, and is setting a we're going to set for a judge's review, and that's going to be March 13, 2025, 11 o'clock a.m. Jill Gukin is appointed to represent the defendant. Any prior release conditions are affirmed. So that date again is a judge's review, a special judge's review at Justice Court, March 13, 2025 at 11 o'clock a.m. with Judge Foster. And then finally, we have some city court matters to take care of. And this is going to be for, looks like we have a total of 6 warrants, which were issued for failure to appear on about 10 different charges, misdemeanor charges, for which the defendant does have a right to remain silent, and that anything he says can and will be used against him. And it looks like there's a special note by Judge Maldonado that the defendant has never appeared out of custody since any of the matters have commenced. So we do have a substantial failure to appear history. Court will set, given that bond's already set in the other matters, the court is just going to set bond in this matter to ensure appearance in the amount of $500 cash or secured. Court will appoint, looks like we'll go ahead and I'll appoint Mr. Grinkowicz again, Jeff Grinkowicz, to represent the defendant. We'll see if that can be helpful. And any prior release conditions additionally will be affirmed. Okay, and so next court date for all those city court matters, that's going to be on March 21st, 2025, 1:45 PM. With Judge Maldonado at the city court, March 21st, 2025, 1:45 PM. Okay, lots of different hearings and information. Mr. Wilburn, any questions at this time?
No.
Okay, with that, you are excused. Thank you very much. Okay, that should do it for today's initial appearances. Thank you, counsel. Thank you, pretrial services. Thank you, jail. Have